employment contract is either the clearest protection your company has or the most expensive promise you didn't realize you made. For the executive signing one, it's either your leverage or your trap. The difference usually comes down to 3 or 4 clauses most people, they just skip right past. Hey, my name is Alex Castro. I'm a labor and employment attorney with AXC Legal based out of Fort Lauderdale, Florida. Everything that we're going to talk about, it's just general information and it's not legal advice. If it sounds like something you're dealing with, make sure you consult an attorney in your jurisdiction to actually talk those issues through with you. You may have heard of at-will employment before, and at-will employment is the default rule in 49 out of 50 states. All at-will means is that an employment relationship can be terminated for any reason as long as it's lawful. That means if I'm a company and I don't like the color of the shirt you're wearing, that's a perfectly legal reason for me to terminate me. What is prohibited by at-will employment is unlawful termination. So you can't terminate somebody because they are in a protected class. That's just called discrimination, or because you retaliate against them because they engage in some sort of protected activity under law. An employment contract, though, can change that default. A lot of people prefer to have a term in their contract that says you can only be terminated for cause. That means something that's actually substantive, and you can define cause to be whatever it is that you guys want to agree on. Typically, cause will talk about failing to follow company policies and procedures, straight up not being good at your job. And a lot of folks prefer that because they want to make sure that when they're being fired for something that actually kind of makes sense and not just some arbitrary reason. Employment agreements, unsurprisingly, also talk about compensation. What is this employee's base salary going to be? What kind of bonuses are they going to make? What kind of incentive pay are they going to get, like commissions? What type of equity awards they're going to be getting? And while all that sounds great, if you don't structure this language properly, you might be agreeing to things that you didn't actually mean to. For example, commission structures are probably some of the most hotly contested compensation schemes out there, because commission structures only ever assume the best possible scenario. They assume only this person makes a sale of X, they're going to get Y percentage. So lay out those criteria in the agreement if you don't have a separate bonus plan already in place that you're incorporating into the agreement. How does somebody get a bonus? Does it depend on their performance? Does it depend on the company's performance? When does an employee actually earn that bonus? Is it at the date that it's paid? Is it at the end of the fiscal year that the bonus represents? Equity awards are a whole other can of worms. Typically, they're governed by a completely separate document or equity plan. Using a template from the internet is just going to get you in trouble 9 times out of 10. You don't think about what can go wrong or what this employee might actually want, or what has already been promised to them that you may not even be in the loop on. An employment contract needs to be tailored to this hire. It's already assumed that something bad is going to happen, because otherwise you're going to get caught with your pants down and you're going to end up in a situation that you don't know how to handle because you took something off the internet that didn't actually account for how your company likes to do things and how your company likes to approach certain situations. And if you're an executive who's coming on board at a company, I need you to understand that this is the point in this employment relationship where you have the most leverage. Start with, what is termination going to look like? Chances are there's already something in there that talks about at-will employment, which is fine if you want it, but if you want some more certainty, negotiate a just cause termination provision where if you're going to be terminated, it's only going to be for some legitimate reason. Now is also the time to start thinking about severance. The most successful executives I see have pre-negotiated their severance so that when the employment relationship ends, there's not some separate discussion, not some holding out hope that the company will extend you severance. And that'll spare you the confusion on the back end of getting slapped with a sudden termination and knowing that you're going to be set for at least a couple more months while you figure things out. And if you've been presented with a non-compete clause either in this agreement or in a separate agreement that's also being handed to you at the same time, now's your time to negotiate that as well. And there's a lot of ways of doing it. A lot of companies won't necessarily give on the non-compete as a whole, but there are a lot of ways that you can limit it. Many companies often know who their competitors are. Ask for an addendum that says, I will not compete by going to X, Y, or Z company, so that you have actual clarity. You might also have an honest discussion about what exactly is the company looking to protect. Those can be covered by stronger confidentiality and trade secret provisions. There is maybe a world where you don't have to have a non-compete at all because everything that company is actually concerned about can be protected through separate agreements that don't restrict your ability to earn a living on the way out. And finally, take a look at what that dispute resolution clause says. Often there's a provision in there saying that if we have a problem, we're going to either take it to arbitration or we're going to have mandatory mediation. If there's a venue provision in there or a choice of law provision, make sure that that applies to where you are going to be working. If the company is based out of one state but you live somewhere else, the employment laws of your state are going to be what govern and protect you. So make sure that that is what's actually written in there. And if anything that we've talked about today sounds like an issue that you're dealing with or that you need help with, click the link below to schedule a consultation with me.